Hey there, in this video, I'm going to be sharing with you my controversial opinion regarding whether you should actually file a written response if you were served with a restraining order. My name is Veronica. I am a criminal defense and domestic violence restraining order attorney here in California, and I help people put their cases behind them so that they can enjoy their lives and their freedom. And I am also very proud to say that I am the creator of a course called Defeat the DVRO, which teaches you how to represent yourself and get your best possible chance at winning. There's a free class that you can find in the description box below. You have nothing to lose. If you are thinking about representing yourself, or maybe you don't have a choice and you know you're going to have to represent yourself at your restraining order hearing, make sure that you at least take the free class. Okay, so let's get right into my very controversial opinion that I'm sure that the courts would not like me to share about whether or not you should file a written response to a domestic violence restraining order. Okay, so if you are watching from California and you were served with a restraining order, you were also served with a bunch of instructions and like this blank packet. There's a document in there that says DV 120. Response to request for domestic violence restraining order. And if you're just glancing at this stuff, it looks like you have to fill that out. Like you have to file this written response in order to actually contest the restraining order. So, and you may be reading these instructions and thinking, man, what am I supposed to write on here? This is filled with lies. I don't even know what to say about some of this stuff. Okay, well, the truth is that you do not have to, in the state of California, file a written response to a domestic violence restraining order. And if you don't believe me, look at the top of your DV 120 where it says, use this form if someone has asked for a domestic violence restraining order against you and you want to respond in writing. You don't need to respond in writing. So since you don't need to, then you should be thinking about, well, do I want to? Is it to my advantage to do so? And overall, I do not think so. I do not typically have my clients file a written response unless the court has expressed that they really, really want a written response in advance. Some courts in San Francisco, for example, want that. But in general, I think that it's a bad idea. However, let's go into the pros and cons so that you can decide for yourself. And actually, before I get into the pros and cons, let me give you some context on how all of this works. So the judge who signed the temporary restraining order, the document that you were served with that probably prohibits you from contacting the other party until the hearing, maybe it includes an order saying you have to move out, you can't see your kids, all of that, that probably is not going to be the same judge who actually appears on the hearing date, like the date on your paperwork that hopefully is the front page. It's probably going to be a different judge. Now, the judge who is in charge of the case on the hearing date may or may not look at any paperwork in advance. I mean, the judges in these restraining order courts are so bombarded. They, from like 8:30 to 4:30 with a 1.5 hour lunch break during which they're probably working on paperwork for a lot of it, are listening to these hearings. So they're not reading it probably weeks in advance. Maybe they're reading them during the hearings. But how this will probably go is that on the day of the hearing, if the judge finds out that the hearing is going to move forward, at some point during that day, the judge is going to open the file for the very first time and read whatever paperwork may be in there. So if the petitioner has filed a request for domestic violence restraining order with at least some part of his or her story. That's what they use to get the TRO in the first place. And there could be your statement in there, or if you choose to not file one, then there won't be your statement in there. But after the judge reviews the file, there's still going to be a hearing. And during the hearing, the judge will allow the petitioner, so that's the person who filed the request for the TRO, for the domestic violence restraining order. If you're the person defending against one of these, that's the other party. That person will get a chance to give more information, more evidence, call any witnesses that he or she may want to call, and then you will get to tell your side of the story. So let's get into the pros first. Now, the pros of submitting your statement is that perhaps the judge sees your side of the story in advance. Now, if the judge were reviewing this the day before, the night before, knowing that the hearing and they probably have 30 hearings on your hearing day, was for sure going to go forward, maybe this would make a big difference, because then the judge could look at their statement, look at your statement. If yours is really compelling, really contradicts what they say, and you've attached some evidence that is also really compelling and disproves some of the allegations that they've made, then that helps you, because then the judge going into the hearing is thinking, okay, well, you know what? I think that respondent has something here. I think petitioner, I've got some real questions for petitioner. So you have a leg up going in. But as I explained, most of the time it's probably not going to be like that. So when you're deciding how heavily to weigh, the judge seeing your side of the story early, probably not that heavily from my experience. And I've been doing this for over 10 years now. Second is that if you get nervous public speaking, like especially if you feel like you just can't, then you can get your point across without having to say it out loud. So if you feel like there's just no possible way that you can stand in a room, look at the judge, and give your side of the story, this may be your only option. If you simply don't like public speaking, then unless you find that the other pros outweigh the cons, I would say you should probably get over it. If you're someone who is going to lose your temper, though, giving your side of the story and answering, I know that may be easy to say, and it sounds easy to say, and you can get over it, but it can take a long time. But if you simply just don't like public speaking, I think that if you are telling the truth and the allegations are false, or for the most part false, then it's worth it to not just rely on the written statement in exchange for not having to speak in public. And, you're not going to be looking at a whole audience. You're going to be looking up at the judge, and you can imagine the judge in his underwear if you need to. The third significant pro is that it can be easier to get evidence in if the other side doesn't object to it. So getting evidence in is something that is rather complicated. I do explain it in my course, Defeat the DVRO. But if the other side is not an attorney, they don't have an attorney, and you attach, for example, text messages that are really damning to their side to your response, and they don't object, as long as there's nothing significantly wrong with bringing them in, like they're a screenshot of a screenshot, or a printed out screenshot of a screenshot that you've taken a picture of, for example, with your hand in the picture, or their hearsay, their conversation with somebody who is not the other party, then most likely they will come in. But let's get into the cons, because the cons are so significant here that it's really important to really think about this before you go ahead and try to write your own statement out. If you write your statement out in advance, you have to give it to the other side. And now you're giving the other side more time to prepare. They're looking through whatever you're saying there, and just like you should be, and you hopefully are, and if you're taking my course, you're for sure doing, just like you are looking through what they wrote and figuring out, okay, what text messages do I have to discredit this? On this day, when she says that I was at home committing all this domestic violence, actually, I was at work, and I have proof of that, and I'm going to gather it, and I'm going to bring it in. Why would you give her that advantage unless you have to, or unless the pros significantly outweigh the cons for you? There's no reason that you have to do that. So I really think that this is the major disadvantage when I'm going up against another attorney. This is something that I know that they're going to prepare for this. If I give them my client statement in advance, they're going to prepare their questions. They're going to prepare their cross-examination. They're going to prepare the petitioner's testimony. If my side gives a story that the other side didn't tell, the other party didn't tell his or her lawyer, well, now the lawyer gets a chance to ask his or her client about it, right? So I don't want to give them that advantage. I don't want to give them any advantage. They've already filed this domestic violence restraining order against my client, kicked him out of his house, maybe sleeping in his car. I mean, all these terrible things that happen to people based on one of these things that didn't necessarily need to happen. And I'm for sure not giving them an advantage. So this is the main one that I think you should really, really think about. Another big thing is that if you are, so like I said, the judge will look at all of the documents before, maybe read them thoroughly, maybe barely read them, maybe actually not looking at them, right? If he or she doesn't have a whole lot of time. But you may make a statement. You may voluntarily decide, okay, well, I did submit something, but I left some things out, so you're going to make a statement in court. You decide you're going to do that. If you say something inconsistent from what you wrote in your paperwork, now the judge can notice it on the judge's own and not believe you. The other side can point it out. You open yourself up to what's called impeachment, where you say one thing one time and you say something different another time. And overall, it's like, well, I guess we can't believe you at all. You don't want to fall into that trap. And the thing is, maybe you're like, well, Veronica, but I'm telling the truth. This isn't for me. This is, for other people who are lying. Especially when you're in a stressful situation, and especially when you're trying to remember events, it can be very difficult, and your memory at one time may be different than another time. It doesn't mean that you're lying necessarily, but if that happens and you are inconsistent, it may look like you are lying. So be very, very careful with that. Another con is, how good of a writer are you really? Are you good enough to write an article? Are you good enough to write for a living? If not, and if you're going to write something that has a bunch of errors in it, or is not grammatically sound, is something that, if I were writing on my own behalf, might be far too dry and not emotional enough and not convincing enough because it is devoid of emotion, then you may want to reconsider. If you give testimony and you're talking about something that was upsetting to you, or you're explaining to the judge, look, that's not true, that simply didn't happen, you can say it with emotion. You can convey emotion that just simply isn't present in writing. Now, of course, that can go the other way. If you're going to get angry, if you have problems controlling your temper, then maybe it would be better for you to respond in writing. But one thing that's important to note is that if you just give a statement in writing, the other side still gets a chance to ask you questions. So if you're trying to avoid saying anything in court at all because you know you're just going to get too angry, for example, know that you can't completely avoid it. Perhaps the other side won't know that they can ask you questions, or when the judge tells them, hey, you can cross-examine the respondent if you want to, perhaps they won't ask you very many questions, or they won't ask you any, but they still have that chance. So you're giving up a lot in exchange for a chance that you won't have to testify. Overall, as I said, in my opinion, and what I do for my clients is almost always, I do not have them write a written statement. I think that the cons significantly outweigh the pros. The thing is, you have to be ready and you have to know what to do at one of these hearings. Now, I mentioned at the beginning of this video that my opinion is probably not popular. The reason why I don't think that it's popular is because the courts want to encourage people to respond in writing. And by the courts, I don't mean your court. I don't mean the judge who's going to be deciding this. They want to encourage everybody to respond in writing because the courts are clogged. Their dockets are very busy. They do often have way more hearings than they can actually hear in a day for these things. But this is your case. This is your life. Do what is to your advantage, not to the court's advantage. Again, I do recommend that everybody at least take the free class that I have. It's free. It's there. You take advantage of it. It's for you. Watch more videos on YouTube. I have more videos about restraining orders. But if you're going to represent yourself, I think that the best course of action is to learn what to do and not file one of these written responses. I hope that you found this video helpful. If you did, please do not forget to subscribe and ring the bell.